Hey, everybody, and welcome to Thursday night. John Skiba here on the Consumer Warrior YouTube channel. And like we do each and every Thursday night, I'm here to do the live stream Q&A where we're going to talk about bankruptcy, debt collection lawsuits, and all the other horrible debt things out there. But yeah, welcome to Thursday night. Barely got this one in. Just finishing some stuff up here in the office, which looks like a tornado hit it, but we're getting some work done today. But what we do each and every Thursday night is if you have questions on how to deal with debt issues, particularly debt collection lawsuits. That's basically what I do. I'm an attorney here in Arizona, and I defend people who are sued by debt collectors. We sue debt collectors when they don't follow the rules. And then I also do a lot of bankruptcy practice for consumers, mostly Chapter 7, Chapter 13. As I always have to do is do my little disclaimer here that this can't be considered legal advice. We likely haven't ever met. I don't know the facts of your case. We're just chatting on YouTube, so take that what it's worth. And I'm only licensed in the state of Arizona. So if you need an attorney in your particular state, highly recommend you contact them and get specific legal advice for your state. Now, how we do this is on the YouTube part of this. I live stream this both to Facebook and YouTube, and I only have it set up so you can put comments on the YouTube version. I'll go ahead and do my best to discuss it, maybe give some pointers as far as how you can deal with some of those things. One thing I was going to mention is I've gone back, I'm giving LinkedIn another try. So if you happen to be a LinkedIn person, I'm going to start putting more videos up there as well, and some additional content that's different than what I do here on YouTube. Go ahead, and this is my profile over there. Let's make a connection there, and there'll be some additional stuff above and beyond what we do here on the YouTube channel. All right. Well, let's see if we have any questions already. We got Easy Bake Barbecue, very first tonight. Nice job. But let's talk to Mary here. She says, if I have a debt collector sending me an email saying you'll settle for a lower amount, do I need something else in writing, or will that suffice? That's a great question. So when when you're negotiating settlements, a lot of debt collectors traditionally have just done it over the phone. They're calling you on the phone, you pick up, you're making some kind of deal, you put it in place, and they want to take payment right then and there. General rule you should always follow this rule. Don't pay anybody any money unless they're providing it to you in writing. I've seen it too many times where a collector reaches out. They're like, hey, we'll settle this for 10 cents on the dollar, but you got to pay it right now. You pay it, and then next time you call in to show that there's nothing owed, you get a different collector, and they're like, I don't know what you're talking about. That was just a payment. So make sure you get it in writing. If they're sending you emails and they send you an offer, kind of basic contract lies, they're submitting an offer, then you need to accept it. So if they're saying, hey, we'll get rid of this thing if you pay $1,500 and you pay it by February 28th, something like that, you can respond and say, I accept. I'll settle the debt in full by paying $1,500 on February 28th, or whatever the terms are. You do that, then you have a deal. And that's something that'll hold up. That'll hold up in court. And so then you'll have that's sufficient. Often when the debt collectors I work with, once an agreement's reached, they just email me a letter. We call them SIF, settled in full letters. They'll send that letter over. That's sufficient for settlement. So, all right. See what Cherry has to say. First time in court, how do you deal with the nervousness and conjure up some kick-ass backbone like you have now? There we go. Here's the dirty little secret. All attorneys are nervous when they go to court. Almost always. I say I don't feel nervous when I'm doing these kind of cases, but if it's like a couple years ago on my YouTube channel, I posted my argument with the Court of Appeals. When there's a lot on the line and you're in a kind of a bigger forum, yeah, everybody gets nervous on that. So, the nervousness, the one thing that I recommend people do, if you're representing yourself, one of the best ways to get over nervousness is to go to the court, weeks in advance and just sit in the back and watch how the court does it. These are public proceedings. You're allowed to be in there. And I remember as a brand new lawyer, I had this mystique of what court was going to be like, and I was terrified. And I remember I went with the partner that I was associated with in the law firm. I was his associate. I went with him and I watched him do it. And I thought, I can do that. That's not that hard. And same thing for a short period of time early in my career, I was a prosecutor with the Maricopa County Attorney's Office, and they just throw you into court and basically say go. And after a while, you're just like, this is, everybody's just kind of fuddling around, and eventually you can do it. So, but that's my number one advice: go there early and check things out. Because if you see how the court operates, it takes a lot of that, just that initial part of it off of, the nervousness of not knowing exactly what to expect. I always remember the first time I walked into a courtroom, there's two tables for the counsel, and I didn't know which side to sit on. And little things like that can stress you out. Some places will say defendant and plaintiff, but sometimes it won't. And so you don't know which side to sit on. The answer is the plaintiff sits closest to the jury box and the defendant sits the furthest away. The problem is a lot of smaller courts don't have jury boxes, and then hopefully they have signs for you. So thanks, Dave, once again for supporting the channel. I sincerely appreciate it. So, all right, let's see this here from Easy Bake. Good evening, Easy Bake. Where is the best place to find how to draft a motion to dismiss for failure to prosecute? The motions in general, particularly something like that, it doesn't, all it is, all a motion is just a formal way of saying, hey, judge, we want you to do something. And so what I would do is just draft you can call it motion to dismiss. And then you just put a little thing that says, hey, we're filing this because they're failure to prosecute, and then lay out what they haven't done. Hey, this case was filed in, January of 2021. There's been no discovery. There's been no motions. They haven't asked the court to set a trial date. They haven't done anything. If they haven't communicated with you, if there's no emails, if they're not responding to your phone calls, kind of just lay just think, if you were a judge, what would you want to see? If you were going to dismiss a case because they're not prosecuting it, what would you want to hear? And likely what you'd want to hear is that they haven't done anything. So there isn't, I don't have a template for it because it's really factually based as far as what the plaintiff is not doing. But that's all it needs to be. It doesn't need to be too formal. Too often we get caught up in the legalese of this. The judges want to read something that's fairly brief, that makes sense, has the facts out there, and is supported by evidence. If you can do that, you'll be fine. So that's probably the easiest way to do it. So, all right. That may be it for the questions. We might be short tonight, which is not a horrible thing because I've still got another hour's worth of work to do here in the office. But yeah, each and every week we're here. Go ahead and put those answers up, and let me put up the LinkedIn thing. If you're on LinkedIn, go ahead and let's connect on there as well. I'm gonna try to put up some written content. I used to be quite the prolific blogger, and once video actually became easier because I could just click record and you're not having to type the whole thing out. But I'm going to try to put some more written content on there. All right. Kevin and Karen jumped right in while I was stalling there. Kevin asks, during a Chapter 7 bankruptcy process, is it rare for creditors to object in a no asset case? The answer is yes. It's extremely rare to get an objection from a creditor in a Chapter 7 bankruptcy. I've been doing this almost 20 years, and I can literally count on one hand the amount of times that it's happened. Usually the only time you get a creditor objecting is sometimes you'll get it like in divorce cases, if there's some like child support or alimony, the other spouse, the ex-spouse may file if they feel like they're concerned that their alimony or their spousal support or whatever is going to be impacted by that. Rarely will you see it when there's been cash advances or large credit card purchases right prior to filing. I've literally had that happen once, and I knew it was going to happen before we even filed it because there was just this gigantic charge of like 20 grand literally in 1 month on it was a business thing. So I kind of knew that was going to be an issue, but with everybody else, it's extremely, extremely rare. And I know like a lot of my clients kind of lose sleep over that. And I'm like, it's not going to happen. They have to have a legal basis to object. They're not just saying, hey, I don't want my debt to go away. Of course, none of the creditors do, but they have to have a legal basis to do it. And there's very limited categories and exceptions to the discharge on there. So, all right, let's see what Karen has to say. My question is how to deal with a collector who got a judgment on you and now they're trying to send a payment deal when I was not served with the summons to go to court. So this is fairly common where there's a default judgment that gets entered against a party and they weren't served. Most judgments, I've talked about this before, 95% of lawsuits, debt collection lawsuits, it ends in a default judgment because an answer is not filed. Well, the big reason why a lot of those aren't filed is because service doesn't happen properly. Service in most states requires that the process server, a constable, a sheriff, whoever is doing it, has to bring over a copy of that complaint and summons to drop it off at your house. Most states they have to put it in your hand, kind of thing. But like Arizona has a rule that says if the process server comes by and they can't serve you personally, or if you're dodging service, they can get an order called an alternative service order where they can just like tape it to your door and send it in the mail, and that counts. The problem with that is often they might have a bad address in the first place, and that's why they're not ever catching you home. Two, I've seen it where the tape it to the door and the wind comes up and blows it into the bushes and nobody sees it. There's all kinds of issues related to that. So if you didn't get served with the summons, in most states, it's Rule 60 under the Rules of Civil Procedure. You can file a motion to vacate it. And if you're saying that the default judgment is void because they didn't serve you correctly, you can actually do that at any time. Usually when you're asking a court to set aside a judgment, you have like a 6-month window to do it, 6 months after the judgment's entered. But in the case where judgments are void, in a lot of jurisdictions that I've seen, and particularly here in Arizona, it can be super old. The idea being that if they didn't take the first step correctly, everything else that followed was void, so the court can unwind that. So that's something I mean, at one time I had a judgment that was more than 10 years old. We got vacated just because they didn't do service correctly. So, oh, and I see you're saying there was a previous address on it. Yeah. But the thing is, to file a motion to vacate, and I have a tutorial. I have the templates here in the chat. If you want to click on that link, there's a online tutorial about how to file a motion to vacate. You're going to have to come in with proof. So if it was like, I just filed a case recently where we filed the motion to vacate because my client did not live at that home anymore. They had moved and they were actually renting a different place. And so we had to attach the new lease agreement and basically show, hey, here's the utility bills. Here's all that from the new place, so that we could have proof that they didn't live there. You can't just come in and say, I didn't get it. The court's not going to take that. You're going to actually have proof. So, all right. We'll do one more here for Easy Bake. Several cases that started in October 2020 answered, filed a request for documents, and just over a month later, they sent something, but not the things I asked for. And since then, nothing. So if you're sending over a formal written discovery, request for production of documents, request for, interrogatories, that kind of stuff, and they're not responding to it, or if they send it over and they do the little trick that they always do, they object to everything over some stupid thing that is baseless, you can file in most jurisdictions what's called a motion to compel. It's a motion that's filed with the court. You're compelling them to turn over that. And basically you're saying, you're kind of telling on them. You're saying, hey, judge, I asked for all this information and they're just blowing me off. Usually there is a requirement that you reach out to them and try and, have good faith effort to try to resolve that before you file that motion to compel. But it's a pretty powerful thing. The court can sanction them for doing that. It can end up being a pretty big deal. So, all right, Alex, thank you. Shout out to Yuma, Arizona, as always. All right, we're going to wrap that up then tonight. We're going to get done a little bit quick because I've got work to do. But hey, I appreciate everybody checking in, everybody that supports the channel. Head on over to LinkedIn. Let's connect there. And appreciate you watching tonight. We'll catch you next week.